on the Fairfax Town Council. Fairfax is sort of a western suburb in Marin County. We're the most westerly suburb as you go out Highway 1 towards the beach. And this whole wave of technology came to my attention at the beginning of the year. Fairfax has always been sort of in a leadership position. We're a very small town, and there's, it's a very tightly knit community, and it's had sort of a culture of environmental activism. We ban pesticides from the town of Fairfax in all public spaces. And when this issue was brought to my attention, it seemed to me we had another kind of pesticide issue. In other words, an exposure of the residents to a substance or a mutating process that could adversely affect their health and welfare. And Fairfax has been well aware of the issue for many years. We passed a wireless telecommunications ordinance about 15 years ago when the cell phone companies wanted to start plastering cell phone towers throughout Marin County, and they're looking for line of sight placement. And Fairfax has a few prominent ridges along the major transportation corridor that they were interested in, and we passed a wireless telecommunications ordinance which attempted, in the minute fraction of jurisdiction that we have left after the 1996 Telecommunications Act, to regulate their placement and use. For example, our ordinance specifies that we don't want to place them near daycare facilities, schools, churches, anywhere where you could have long-term exposure to large groups of citizens, particularly young people, because we know that their immune systems are much more sensitive, not as well formed, and they're much more vulnerable to mutations. So we have actively managed our wireless telecommunications through that ordinance. Since I've been on the town council since 2003, we've had 2 applications by cell phone companies to construct cell phone towers. The one I had to deal with when I was mayor about 4 years ago, we'll wait for that flyover to finish, we climbed to the proposed site of the cell tower, and one of my friend's kids was down below in a playground in a little school uniform for St. Rita's, and yells up to me, "Hi, Larry!" And that was the end of the cell tower location above St. Rita's school. And we sent them scrambling to try to remap really what type of coverage they needed, and we prevented that cell tower from going in there. What happened with PG&E is another story. We got wind of it before they deployed the meters in Fairfax, and a group of us started researching it. Frank Egger, who was sort of the emeritus mayor of Fairfax, longest-serving town councilman in California history, did some research. We have an old franchise agreement with PG&E under the 1938 Franchise Act, and we did some research, and under that act, the local jurisdiction has the authority to impose terms in what it thinks are or is the welfare and health of the community. So we have another little fraction of jurisdiction under our franchise agreement with Fairfax. We've got our Telecommunications Act that we passed, our ordinance that we passed long before the smart meters were rolled out or even contemplated. And so we could kind of see this tide, this really tsunami of technology quickly approaching us. And we drafted an ordinance which incorporated those 2 things, our Franchise Act, our Telecommunications Act. And in further researching it, there's general PUC law that says that the utilities have an obligation to cooperate with local jurisdictions. So with all that background in mind, what we eventually found out as this thing got rolling, we introduced our emergency ordinance in August of 2010. We passed it on an emergency basis on August 4th of 2010. Was that PG&E, before that had come up to the council, had already installed what they ominously call their data collection units. So what a data collection unit is, it's essentially an antenna, a powered antenna that picks up the broadband signals from this mesh network of smart meters and then downloads that data on a cell phone connection, which is wired into that smart meter DCU, the data collection unit, which, you know, it really, you couldn't, Philip K. Dick, a famous science fiction writer, you really couldn't come up with a better name for this device that they installed. They installed 4 of these throughout the town of Fairfax. They never consulted with the town of Fairfax. They never went through our wireless telecommunications ordinance, which requires them to consult with us and get a use permit to do that. You can't just put this huge powered antenna anywhere in our jurisdiction without at least getting a use permit. And one of the requirements of getting a use permit is notification of the residents, so that residents who choose to live in the area at least can come in and weigh in. Because we know we always make better decisions when we have that kind of input from residents. And that's really the story of Fairfax, is empowering people to come in and really have sort of a proactive impact on what happens in the town of Fairfax and what kind of regulations, what kind of environmental future we want to craft for our community. Well, that didn't happen with PG&E. So the 4 data collection units were put in. They violated our telecommunications ordinance. They never even told us that they were going to do that. So those are the units that download the data. The cell phone company that has that contract is Verizon. It's one of the telecoms that was implicated in the illegal NSA surveillance that was done during the Bush administration. The data is downloaded and organized by Oracle. Oracle is well known as far as its involvement with the NSA. And another interesting note as far as Oracle is concerned, Oracle was just sued by the federal government on an allegation of a $200 million fraud of the federal government. So the trustees of our data are not above reproach at all. So the trustees of the data are not the government, they're private corporations. And the problem we have with that, as far as the sort of the architecture of democracy is concerned, is that there really are no adequate regulations addressing the use of the data, the collection of the data, and the resale of the data. Smart meters, currently an electromechanical meter picks up 1 piece of data a month. It picks up the amount of electricity you've used from month A to month B. Smart meters, at a minimum, are collecting data on residential users once an hour. So instead of 1 piece of data a month, at a minimum, a smart meter in a residential setting is collecting 720 bits of data. So obviously, it's a much more highly granulated, detailed data collection of household activities. And one of the things that attorneys and judges have been trying to do for years, and it is protect privacy. What is privacy? We've all been brought up to believe our home is our castle. What we do in our home within certain broad legal parameters is private and is our own business. Obviously, 720 bits of data a month, there's a lot that can be inferred, just as Rob was talking about what you're doing, when you're doing it. Are you using some kind of a health device, breathing device, or other device when you're using it? Are you home? Are you not home? When are you home? This has tremendous implications as far as even defining the expectation of privacy. What do people believe is private anymore? It used to be that we believed what we did in our homes within certain broad legal parameters was private. Well, obviously, with the smart meter technology, we have to think again, what is private? What do we define as private? So it really is going to have a very profound impact on the expectation of privacy, and the Supreme Court has addressed it. There is a case that we actually incorporated into our statute in Fairfax called People versus Kylo. Kylo was a case where the government employed thermography to inspect a home that they suspected was involved in marijuana cultivation. And it went all the way up to the Supreme Court. The Supreme Court threw that case out. Judge Scalia himself, that well-known privacy and First Amendment liberal, wrote the decision, and he said that, the technology invaded the four walls of the home, and they needed to get a search warrant to employ it. And that's much cruder information gathering, really, than the smart meter, especially now that we have Rob's information, where you can actually interpret the signal that's being sent through the meter and not just the usage, which is what my example is really based on. Commercial meters are going to be collecting data at once every quarter hour, and the meters have technological capability of probably, once every 10 seconds. But that's data overload. I mean, even PG&E can't manage that, which leads to the next point about who will manage it. It's not just going to be PG&E. It's very valuable data. Corporations like Google are very interested in getting into it as sort of a secondary market, a secondary gleaner, a secondary miner of this data. There has been, and these questions have been well documented. It's not just, Fairfax. UC School of Information submitted a very critical paper to the National Institute of Standards, which addressed it and which urged regulators to build privacy into the system and not to bolt it onto the system. Because once you try sort of catching the dragon after you've let it out of its cage, it's much more difficult to do that. So the privacy experts and the security experts have really been urging regulators to build privacy in, design it into the system, not to try to bolt it on. And unfortunately, that really hasn't happened. What did happen, which I just told Rob about, is last week Governor Schwarzenegger signed a very much compromised privacy bill authored by Senator Padilla, which addresses ownership of the data. But it really doesn't address a lot of the other sub-issues that are involved in privacy. How long do you get to hold on to the data? Who gets to see it? Can you resell it? What can it be used for? And all those types of things. And ultimately, even if you get some kind of a regulatory scheme in place, which we don't, ultimately, the invasion of privacy is inescapable, because even if, it's not Big Brother looking in on you, which it inevitably will be, because electronic data has a lot less legal protection than physical data and physical objects under the Fourth Amendment. And we know even the Obama administration is trying to get coarser and coarser regulation of electronic data, whether it's your email, whether it's your Google searches, all those types of things. The government wants to have a handle on that in this increasingly frenetic war on terror, security, phobia is now being used to justify, the continuation of the military-industrial complex, among others, the prison-industrial complex, whatever you want to call it. The data, even if it's not misused in that fashion, is obviously going to be subject to subpoena in litigation, like you mentioned. And that's going to degrade the expectation of privacy that we have, that we expect, and that we actually have for ourselves. What are we trying to do? What is our strategy? Our strategy right now in Fairfax has been to try to light a backfire against this wildfire of smart meters that's going to sweep over our area, and as already is sweeping over. We're trying to get the word out to our sister communities. San Anselmo may take our town adjacent to us is taking up an ordinance to ban them, to put a moratorium on them. We're trying to get the word out to other jurisdictions. I think Santa Cruz, Watsonville, they've passed legislation against them. But ultimately, PG&E, the barbarian is at the gate. We've held them out. We've held them off for a little while. They've sort of been intermittently putting in a few meters here or there that they claim are required in order to do repairs of old meters, that type of thing. But, the showdown hasn't really occurred yet. We haven't gone to court with them. We've sent them what they call abatement notices. An abatement notice is, let's say you build an illegal addition to your house without getting a permit. The municipality would send you a notice to abate. You've got to buy your permits and pay your penalties and bring things up to code, or you remove the offending structure. And we sent PG&E abatement notices about a month ago, and which, so far they've ignored. We've also managed to offend the California Public Utilities Commission in all this, because they are offended that we would deign to assert jurisdiction. They feel that it's their jurisdiction alone which can address this, and it's really a legal question whether they preempt us, whether their jurisdiction trumps the Franchise Act of 1938 or not. Maybe it is. Maybe it does. Maybe it doesn't. We don't know until, you toss the ball up in the air and the courts take a look at it. But in really thinking about it, and as an attorney for 28 years, courts tend to do what movements and communities expect them to do. And if our communities don't expect privacy protection or ignore the threat to privacy protection and the health threats, and we are marginalized in this debate, then the courts will do what they always do to such litigants. They will sort of write us out of history. They will not analyze the health issue or the privacy issue. They'll just hang their hat on the jurisdictional issue, and we'll sort of get written out of history, and our concerns will be excised from the court record, and that's how it works. So I feel it is a political issue. It's definitely an issue that affects our fundamental rights under the Constitution, and it's an issue which affects property values and all the more local municipal issues that you deal with on that level. And really, it's going to be a question of whether the people, the communities, let their elected representatives know that they want protection and that they're concerned about it, and they expect action. We're going to be writing a letter to our state representatives, Huffman and Leno, Senator Leno, we share with San Francisco, to carry legislation which would at least enable ratepayers and residents to opt out of the system, so that a ratepayer who has a special electromagnetic sensitivity is not forced into putting a nuisance on their property. I don't know if either one of our representatives are going to carry that legislation. We're going to be getting that letter out to them last week, or rather this coming week, and the battle will go on until it's ended in the courts, or none of us are left standing. None of the communities are left standing without these ubiquitous networks. So far, in Fairfax, we've managed to keep it out, and I hope you all will think about it as far as what you want for the future of your communities, because you're really the messengers. And it's without you, the elected representatives are not going to act. So we've got to create sort of a counter tsunami of citizen activism and citizen concern to protect our communities. So thank you very much for letting me speak to you.